Hi everyone, it's Samantha Graff Benmore from the Graff Group Toronto, and welcome to another IG Live. I am just waiting for Cheryl to join us, as well as Jordana Talsky. She is with C'est La Vie. Oh, and there she is. C'est La Villa. I love it. Oh, there's Cheryl also. Okay, let's see. Did that work? Hold on. Cheryl Graff joined.
Hi.
Hold on.
Hi.
Oh, I got you both.
Hi.
Okay, we're
How are
good.
you?
Hello. How are you?
Good. How are
We
you?
we are
Good. Good.
great. We just got literally off of Zoom. I don't know about you, Mom, but I just like literally ate something so quickly. And here we are again.
Nice.
Good.
Yes.
So, welcome. I'm very excited to have Jordana join us. Jordana is a wills and estates lawyer, planner, sort of. I guess it kind of goes hand in hand, the two titles.
Yep.
And yeah, why not, right?
Mhm.
So we are going to speak today. Well, really, Jordana is going to speak today to help everybody understand, because I think it's really important. And people have heard the terms joint tenancy and tenancy in common, but a lot of people tend to forget what this really means, or they might not be so clear. So let's start right there and jump into explaining what joint tenancy is and what tenants in common is. Are you
I think,
frozen there,
think we
Jordana?
lost.
Yeah, I
I
think
think we
she's,
lost her. I think she
yeah,
got
but
lost.
hold on. Let's try this again. I just hit accept again on there. Yeah, because she's
There we
frozen.
go.
But she
Okay.
looks so pretty frozen.
Was it like
It
this?
was a good frozen. You know, sometimes when you get that slide of like,
I don't. I hope it doesn't boot me off. Okay.
all
I'm
right.
not touching
So
anything.
we were just
I heard.
let's rewind. Oh, you heard?
Okay.
Okay. Great. So let's jump into defining the
Okay.
two and then we'll go
Okay.
from there.
Okay, great. Yeah, so many people are unaware that uh, to hold property personally, there are these two ways: joint tenancy and tenants in common. Joint tenancy means that there's a right of survivorship and that the owners own the property equally and together. So it could be with two people, could be with more people, but there's a right of survivorship such that when one property owner dies, the other owner or owners inherit the property, and it happens by operation of law outside of a person's estate. So basically, the main thing to remember is it's a right of survivorship and it's outside the estate. And we'll talk about why that can be good.
Right.
Tenants in common, it's not tenants like you're a renter or anything.
Hmm.
It's just a term of art, a legal term. And it means that you own the property in whatever respective shares you are registered as. It could be unequal, it could be equal.
And that's a very good
Yeah.
point because I think people automatically assume it's a 50-50. It doesn't have to be a 50-50 split.
Right, exactly. But it's a way to hold property such that when that owner dies, their share flows into their estate and is then dealt with under their will. So it doesn't transfer automatically to whoever else is
Right.
on title. So we can
Right.
now like discuss why
The
would that be good?
benefits, yeah, and what somebody may want to choose. And look, that could be different for different people. You know, there are people where joint tenancy works in their favor, and there's people that tenants in common would work in their favor. So maybe that's a good place to start. Next is what are the benefits and who would want a joint tenancy
Right.
over tenants in common.
Sure, for sure. Okay, so the big thing that everyone likes is that joint tenancy with rights of survivorship can avoid probate, both the probate process
Right.
and also paying probate taxes or estate administration taxes in respect of transferring that share or interest. So that's very attractive to people. They want to save on those fees. And we often see this with spouses who are joint owners of property,
Right.
and there's an intention that the surviving spouse should inherit the property and like no strings attached or anything. And we
Exactly.
want it to be a fluid transition. So we want to save on the probate. We want it to just flow outside the estate by operational law, bing, bam, boom. So that's a good example.
Mm-hmm.
Tenants in common tenants in common, you do pay probate in respect of the share that is flowing under the testator's estate. And why would you choose to do that? Often it's because the beneficiaries of that person's estate may not be the usual players of a ordinary course, and the people that person may want to benefit may be different. So an example may be like a blended family. Maybe the person owns property with their second spouse, but they want children from a first marriage to benefit from the growth and value or whatever of their
Right.
ownership interest.
Right.
Now, so it's often you have to look at the numbers and you have to look at the specifics, because maybe you have to see like, well, what will they be paying in the probate fees that makes it justified and worth it to do this. Sometimes it's situational, like I just said, and uh, well, yeah, that's actually period. That's the end. And sometimes it's part of a larger estate plan where there's offsetting or there's certain beneficiaries getting certain kinds of assets, and you want to make sure that you can actually distribute your ownership share. You don't want it out of the estate. You want it in your control because there's other beneficiaries inheriting other assets, and you want to be able to equalize the amount people are getting, that you would actually want it to flow into your estate. And it's important to remember that although it is sort of more fluid and a bit simpler to keep it out of your estate, it's actually not a huge tax. Probate tax is 1.5%. On the value of real estate today, yes, that's like not nothing, but sometimes it does make sense so that you can maintain control and do other kinds of planning and leave it to the beneficiaries that you want.
And I think also it's a good thing, like where I think people might pick tenants in common. No, did I say that right? Yeah. It's just the words aren't flowing. Joint tenancy is so top of mind to me. The other one isn't so much. But nowadays, with the cost of real estate, there are a lot of people buying properties together, and they aren't necessarily married. They could be friends or something, so they might want it to go to their separate estate that then would benefit their particular family. Like, they don't want the person that they just did an investment with. They want that investment that they put their money into to go to a family member.
Absolutely. That's a really good point. So then the only caution,
Hmm.
which I'm sure they're thinking about, is if you leave it to specific people, and like the idea is not to sell it when one dies and just distribute the proceeds, but if you actually want co-management, co-ownership to heirs, you have to be really careful, because is there going to be friction? Can they co-own a property together? And those are things that
Right.
we look at when we're doing an estate plan. And
Yes.
really, it's very fact specific. It really comes down to like the people and the situation and what we can do and the confidence level they have in how they want to leave that asset.
But
I
when it's tenants in common, are they able they're able to put a property on the market prior to probate, are they not?
Yes. Sorry, you mean if one person's interest as a tenant in common? Oh,
Say say there's an uncle, for example, and he has his nieces or nephews listed as tenants in common. They would be able to put that property up for sale prior to probate.
so you mean that the uncle is leaving it to the nieces and nephews, or they're on the
They're
property?
on the
And then
property
uncle dies?
and the uncle
Well,
dies.
so it
And then
depends who's getting uncle's share,
the
but in theory,
say the nieces and the nephews, whoever's on title, are getting it.
so it's a good point. So yes. However, There used to be a way to submit for the probate application and say, can you please hurry up, court? We need probate to sell this and we're listing it, or we have an offer or whatever. And my understanding is they're closing that out. They're saying too bad. So I always caution to wait for probate before doing
That's what
that.
we do. Yeah.
Okay, just
We
was wondering if
try
we
not
could
to
have
go
done.
to market. I mean, unless somebody's really pushing us, but our advice to clients is it's much easier. The last thing you want is to sell a house to somebody and then be like, hey, we agreed to a closing date that's in 60 days, and we actually can't
Right,
even
right.
allow that. And then you have to postpone your closing. And no, no, no.
When
It's
in the event
messy.
that that has to be done, I always want to review the offer and make sure that there's a clause for extension. However, like a lot of extensions, but I
Yeah,
still dissuade people from doing it. But they really want
Yeah.
to do it, then that's what you'd
But the
want.
problem, and something for people to be aware of, is the extension could be in the offer as an agreed clause, like a clause that everyone's agreed to. But it also could probably allow a buyer to get out. And if your market changes,
Mm.
it probably is a way there's an ability to like you got to be really careful with your wording to make sure you hold that buyer, because let me tell you, if that happened about a few months ago and you sold it and you went to market now, the buyer would be like, hey, you know what, I overpaid for that house, I'm out, right?
Yeah, yeah. Overall, I just think it's prudent to wait. There's so many moving parts, and I think it is kind of you might be playing with fire if you try to advance without getting probate. That's my 2 cents.
Yeah, yeah. I think that, so I think people have to weigh out the pros and cons, on how this is working in your particular situation. As we say, houses and cases, everything, they're all very unique to the situation and the people involved.
Absolutely. There is this case that I was going to raise. I hope I get
Oh,
the
yeah.
facts right. So it kind of blows my mind though, because it changes what I've come to understand. It was a case in 2023 that then was upheld on appeal in 2024. It's called Jackson and Rosenberg. Okay, so basically, okay, I hope I get the facts right. So Jackson, I believe, was the testator. Jackson transferred a home into joint names with the grandniece of his former partner, who was Rosenberg,
Grandniece. Okay. Grandniece of former partner. Got it. Okay.
as joint tenants with rights of survivorship. So just to refresh, so that would mean that on Jackson's death, Rosenberg gets the whole property outside of the estate, no probate taxes, easy peasy. Okay. So then Jackson found out that Rosenberg and her husband wanted to sell the property so that they could buy some other property or do something with it. And Jackson was upset with that. That was not his intention for what should happen. So I should also just back up and say joint owners with rights of survivorship, you have equal rights. Like you're on title as a joint owner, you have equal rights. Or so we thought until this case.
Right.
So then he's upset. So what does he do? What were his options? So he applied to sever the tenancy, to basically convert it from joint tenants with rights of survivorship into tenants in common. That was the first thing. Um, okay, because what would that have the effect of doing? It would mean that, let's just say in the first instance, if he was able to do that, he would retain 50% and the other 50%, instead of it be, and his would flow in his estate and hers would flow in her estate.
Right.
So he was successful at doing that. And then, so then Rosenberg, she wasn't happy about that. They took it to appeal. And then the appeal court not only said, yeah, this guy can do that. Also, there's a doctrine called the doctrine of resulting trust, whereby if a transfer transfers property to someone and there's no expectation of like of an obligation to pay or to reward for that transfer, it's considered being held in trust by whoever got it for that original person. It's a complicated doctrine.
Okay.
So the appeal court actually found not only are you able to sever the tenancy, Mr. Jackson, but we're also going to find that the 50% that now is in Rosenberg's name is actually being held in trust for your estate. And she got nothing. So it's like it's I think it's a watershed case because previously estate lawyers we were saying like be so careful, and you still do, but be so careful about transferring property into joint owners
Yeah.
with rights to survive. You're going to lose your rights and it's going to go to the survivor and blah blah blah. This case or the whole case law shows that actually you may be able to take back your gift. Now what I haven't read the whole case, but it will absolutely turn on whether the intention was properly documented. So that's why you need a good lawyer to
Mm-hmm.
like what was the intention when Jackson initially transferred it as a joint tenants to Rosenberg? And if you have the proper substantiation,
Documentation.
then
Yeah.
this says you can do that. I still would caution again. I think that's like it's a new case. I don't know, like maybe, but I thought it was super interesting because it really does incorporate both of these concepts and estate planning and all the risks. So like Rosenberg, uh-uh. Yeah, really cool
So
case.
let's bring this also to we probably really need Steve on this call, but I'm thinking, when two people, especially these days, not everyone's getting married, but they're living together.
Mhm.
And depending on who did somebody move in with that person, or
Right.
did they actually buy something together? If they bought something together, they're probably going to declare it because they're buying together. But if one person was already living in the house, and owns that house, and then, maybe
Domestic contract. You
exactly. That's
have to
why I
pay for
said
it.
we might need Steve on this call.
Must, yeah, absolutely. Like red flag immediately when I hear like someone's moving in and they own the property. Domestic contract to protect everybody's interest.
Yeah,
Steve could probably share this doctrine of a constructive trust. So that's a way whereby someone who's been living in a home that they don't own might make a claim on the value of, I don't know, the growth
the
or
growth.
what, or else.
Yeah. Yes, the
Um,
growth of the from the point they move in after a certain amount
and
of
they
years. Yeah.
be trying to argue they contributed to the growth by whatever they did for the
Well,
upkeep of the
especially if they
property and
put some money
improvements.
into it, right?
Yeah,
Like either
yeah.
whether they paid the mortgage, they'd have to have the actual documentation, receipts and everything, or maybe they, put they have bills because they renovated something. But if they put money into it and they show that,
Sometimes there's an intention. Like you don't want to hold up people's good intentions. Like sometimes they want to move into this house and they agree, okay, and we're going to share in the growth, or I'm okay with not sharing the growth. But the main thing is just to preemptively like see a lawyer, get it on paper. You can always modify it. It's really important.
yeah, yeah, no, definitely, I agree.
Yeah, it's
I
worth
do
the
agree.
spend to avoid all the problems that can happen.
I did my matrimonial Monday video yesterday was about the people who, yes, after your expenses of a lawyer and a divorce coach and all the other expenses, your therapy and everything that goes along with divorcing, they come to the realtor because at that point, they've spent a lot of money by the time everyone agrees to sell the house usually, and I said, they want to cheap out on the realtor. That's, they want the lowest commission possible. But, like in anything, you get what you pay for, and when you don't pay for something, it might go the wrong way. Like you really want to hire somebody who knows what they're doing and they're professional. And the people who are really good would respect themselves and not devalue themselves, shall we say.
Agree.
So,
I do
there are
agree.
definitely some restaurants out there that are less expensive than others, and their food and their service is awesome. But I'm not a restaurant personally.
Yeah, I agree.
I'm not in the restaurant business.
Yeah.
But
I guess I'll also add, just for anyone who's curious. So I think that lawyers are divided on adding a child to a home, like older parent, then the child parent wants to add child or children to the home in order to avoid probate and everything else as a joint tenant or as a tenant
it's
common or whatever.
sort
I
of part of the
also,
estate planning,
yeah,
right? Like,
and I also caution. Like that could work in certain circumstances, but to just do it, it's like the case I just mentioned, just you're not sure how things may change in future,
Right.
and then whether you'll be able to go back and go back and change it. Maybe now that there's this case you can, but you have to be so careful. Like I know I get lots of calls. People are just like, yeah, and I'll add my kid to the house. Okay, well, have you thought about all of these things? Because probate, it's okay. You want to avoid the hassle, but sometimes it's worth it. Sometimes you just do it the right way and you pay the probate fee because otherwise it's going to really muck up other things. So I just caution people to
It's a
think it
very
through.
good point, and I'm sure it is something that a lot of people do, at the very least, consider at a certain stage in their life.
Depends on your kid, because all of a sudden you can have your child on registered as an owner. They could go and borrow money against it.
Mhm.
You could wind up in more of a hole
Yeah.
than not. But I have a
Well,
question. When it's joint tenancy, so you're saying it doesn't have to be purchased at the same time. So at any time you can add somebody to it?
Add someone as a joint tenant.
Hmm,
Yes.
you can. So it
Yes, but
doesn't
you'll want to look at any of the
while
tax
you're doing.
implications doing that.
But
And you want to look at the tax implications. You want to also have agreement among all the
yeah,
parties.
that you put them on it.
Oh yeah, for
Okay.
sure. You'll have to get.
Yeah.
Okay.
Good
Yeah. Good
luck.
luck.
Yeah.
Yeah.
well, it depends on the situation, I
It
guess.
depends on
But
the
yeah,
person.
yeah,
Yeah,
Yeah.
yeah.
that's it. So it is important.
Mm-hmm.
But what?
What would be a caution? Let's go to a little bit different, but just sort of we're still playing in this idea of hiring a professional. What would a couple of top questions that you would like caution someone or advise somebody to ask when they are considering a lawyer to represent them? Like, what are some things they should watch out for, maybe, and what are some things they should look for
In a professional.
in a wills and estates lawyer? Yeah, like how that look, just like realtors, there's so many out there.
Mhm.
Why the Graff group, right? Like, we can tell them why,
Yeah. Okay.
but like, but we could also tell somebody we're not the only ones. There's
Right.
people out there that'll do a great job. We'll
Right.
tell you why we will, but we also would say maybe watch out for people who say this or do that. We don't think that works in your benefit.
Sure.
What
Okay.
would you say?
I have some ideas.
How about
Um, okay. So if an estate lawyer or lawyer is not asking in-depth, robust questions about the nature of your asset, they're just going to say like, okay, yeah, who's your executor? Who you want to leave it to? No. Some people are uh, private and they don't want to share a lot of information, and so that part of my job is like, no, I need this
right?
information. If a professional is not asking you those questions about what types of assets you own and the value, or at least the general value, and your intentions behind it, then that's a red flag that you're not going to get a proper will, and you're not going to get a proper estate plan. You might get the document, but whether it's going to function well is in question if they're not asking you about that. Another thing would be, where was, oh, I had, okay, so the asking questions. Um, Short wills, yeah. So a lot of people these days get bent out of shape about the length of a will
Mm,
document, because like, I don't know, 50 years
long.
ago they had a 5-page will or a 2-page will, and now my wills are longer than that, and they don't like that. Yeah, if you're getting like a 2-page will, it's not going to include everything it needs to in a will,
Right.
so watch out
Good
for
point.
that. And
And
that could,
online, what about online wills? How do you? I mean, I don't really know anything about them. I'm not gonna lie.
sure, yeah,
I had a really good lawyer do mine, so I'm,
yep.
yeah,
Well, I
no,
I mean, as you know, Smith, I'm a musician and I have artist friends who don't earn a lot and they've had to resort to using online wills and I've like pro bono checked it out for them. Okay, my opinion on that is that it can work in some circumstances, but you're taking a risk
Yeah.
because they don't account for all kinds of different scenarios. It is limited. If you're filling out stuff, you're not a lawyer and you don't know if you're going to fill it out right. So if it's a very straightforward situation, maybe an online will work for you.
Right.
But there's
Right.
no guarantees and that there's more risk that you could write something wrong or forget something and then you're out of luck. So they're not held in very high regard by bar. But in some circumstances, and it's better than nothing. Like honestly, yes, it's better than nothing to go and do an online
Yeah.
will. And there are some will outfits where it'll prompt you with some questions, and depending on your answer, like your personal situation, it'll bump you. It'll say, "Sorry, this online platform is not going to work for you. It's a little more complex. Here's some suggestions." So I would say if you got to do an online will, try to go with one of those where it's at least asking you some questions to figure out if you're an appropriate candidate for the service.
And what happens actually in different situations where someone does not have a will?
Sure, great question. Every province has legislation or statute that deals with intestacy. That's when someone dies without a will, it's called an intestate estate. A lot of people think everything just goes to the government. That's not accurate. There is basically a list. It says, okay, if you died without a will, if you had a spouse and no kids, it'll be this. If you had no spouse and kids, it'll be this. If you had no spouse, no kids, you had a sister, a brother, or this or that. There's a line, there's an order. And so that is how an intestate estate is distributed. The real kicker, like the problem though, is it doesn't dictate in this statute who's in charge. So someone does have to step up and apply to be the executor. And that is a more complex process when there's no will. I mean, I deal with it all the
Didn't we?
time.
Yeah. Didn't we
So
have a
is it
situation with
a,
this? Didn't
I
didn't we have a situation where there was the will was not there, so and that somebody was applying to be an executor.
I
So we
Are
were
you talking to me?
waiting on that.
Us?
Yeah. Yeah.
Yes. Yes. I
Yeah.
actually just
I
spoke
was
to
like,
that
it
person
sounds too
yesterday.
familiar. Yeah.
Okay.
Yeah.
Great.
okay, because what would happen if so you're saying so a spouse or a child would not be the first person on a list if say one spouse has a will but the other one does not. So are you saying that the spouse or a child would not be the first person on that
No,
list?
no,
There's no
but
will.
I'm not saying that there is a list. If there's a spouse and children, for example, let's say a spouse and two kids, there's something called the preferential share, which is
Okay.
$350,000. $350,000 the estate gets paid to the spouse, and the balance gets divided between the spouse and the kids. Like that's for an example, unreal. But yeah, it is a really good reason for both spouses to have a will because even though
Right.
that's the law of who gets what, the process of appointing someone and then having to follow what the law says is going to be cumbersome and it might not be totally what they wanted. Maybe they wanted a little bit of a different situation. So you shouldn't leave it to that. And both spouses should
Wow.
absolutely get their own wills. Yeah.
Okay.
Yeah.
Good.
Yeah.
All
Good.
righty. Well, I think we answered our questions on joint tenancy and tenants in common, and the pros and cons. And basically, at the end of the day,
Get a will.
call Jordana and give her your situation and let her direct you as to which way is better. And or, as we always say, we will give you the different options and highlight the pros and cons, but you make the decision.
Absolutely.
Right.
So, Jordana, thank you so much for joining us. For everybody who's watching this now or later, which later is more the thing, we just wanted to let you know that Jordana will be tagged on the video, so you'll be able to reach out to her. Say la vie la. I mean, the name says it all. And thank you so much for your time. We really do appreciate
My
it.
pleasure. Great to hang
Awesome.
with
And
you.
take care. Have a
Everybody have an awesome
good
week, and
day.
we'll see you next week.
Take
Thanks,
care.
everyone.
Bye.
Bye.